Hi, and welcome to this latest immigration law conversation. Today, I've got a returning guest, Gemma Tracey from Latitude Law. Gemma, you were my first guest and first immigration law conversation back at the start of lockdown when we talked about the impact of COVID and Appendix FM. Thank you so much for volunteering to come back today.
No problem. Thank you very much for having me back, Adam. It's great to be back.
Today, we're going to talk about two things in one, and actually two things that are linked together. We're going to have a look at the EU settlement scheme, because as the 31st of December approaches, lots of people trying to get their status sorted and make applications under the settlement scheme. And obviously after that, the only route really for skilled workers is the new skilled worker route, which goes live from the 1st of December 2020. So we're going to have a look first at the new skilled worker route under the points-based system. But Gemma, first, tell us a bit about, I know you've been on before, but for those of you who haven't listened to the previous video, tell us a bit about you and what you do.
Sure. So my name's Gemma. I work at a company called Latitude Law. We are specialist UK immigration lawyers, so we deal with all UK inbound immigration. So our workload varies from workers, a lot of European matters at the moment, family members, and I also have kind of a specialism in religious workers, so a lot of religious workers coming to the UK.
Fantastic. In terms of the new skilled worker route, I know we've had your boss on previously talking about this and we don't want to steal his thunder, but just give us a bit of an overview of the new skilled worker route. Obviously, since I did the video with Gary, we've had in October the new rules with lots of new appendices to the immigration rules. We've had a massive amount of Home Office guidance that has just dropped, and I know both of us haven't had time to wade through it yet, but just a sort of overview of the new skilled worker route.
Sure. So the route is for those coming to the UK to undertake employment here. There is already a skilled worker route that exists already, but kind of the skilled worker route is slightly changing some of the requirements. And obviously it will apply to all European nationals from the new year following the end of the transition period.
And in terms, this replaces the old tier 2 points-based system. So Gemma, in terms of the big changes, what are the big changes? Or perhaps there's no big changes, it's more minor tweaks. What's been changed?
Yeah, so there are a few changes from the tier 2 route to the skilled worker route. One of the main kind of significant changes is the skill level. So under tier 2, as it is at the minute, workers can only undertake employment if it's degree level, so RQF level 6 or above. Under the new skilled worker route, that's dropping down to RQF level 3, so that's A-level employment or higher. The Home Office made that change mainly because of our departure from the EU and to try and kind of incorporate some lower skilled jobs into the category. But there are still a large number of jobs that aren't suitable for sponsorship and ones that I certainly couldn't do. So kind of care workers, prison officers, undertakers, you cannot sponsor those under this, and that they are skilled, aren't they? They are skilled work. Other changes include the salary. So the salary threshold is decreasing, and now kind of going forward, the rate will be 25,600 or the going rate for the job. So there's two kind of different salaries. The minimum definitely has to be 25,600 unless the job that you're sponsoring the migrant for is slightly higher than that, in which case you'd have to pay the higher salary. There are exemptions to the kind of the minimum salary. These are kind of dependent on the worker who's coming and the job that they're undertaking. But in a nutshell, it's generally there would be a reduction for someone who's doing a shortage occupation job, for someone who's a new entrant to the labour market, or for someone who has a PhD, which is relevant to the job.
And I think that it's really helpful you say about the going rate, because I think some people look at those headline figures of the 25,600, or even if you're in the shortage occupation, the 20,480, but don't realise it's or the going rate, whichever is higher. Yeah. So I think that's a real important issue that you raise and something people need to be aware of. The government, I know you've heard from the Home Office. I've recently listened to a Home Office podcast. They talk about how much more simple this is going to be and how much quicker it's going to be. What's your reflection, Gemma, on what you've heard so far in terms of speed, simplicity, cost? What's your reflection so far on that?
In terms of speed, I was attending a conference last week, which was attended by the Home Office, and they did kind of an overview of the new route in the conference, and they maintain that anyone who's coming to the UK from abroad will be able to receive something that's called a certificate of sponsorship, so which is what a worker needs to go ahead with their application within 1 working day. But that's only for those who are abroad and are seeking to come to the UK. Those who are in the UK, as far as I'm aware, there isn't currently a priority service. Well, there is, but it's very hard to purchase. There isn't. They'd be subject to the standard 18-week wait for a certificate of sponsorship unless they're going to pay £200 and get onto the priority service, which is very, very difficult. I've been trying since Wednesday this week to kind of get onto the priority service, and every single day my request is rejected because the Home Office only prioritise a certain number of applications each day, and it is quite frustrating.
No, absolutely. In terms of cost, anything else in terms of speed, simplicity?
Simplicity, I wouldn't say it's any simpler. No, the rules are very, very lengthy. They're accompanied by really detailed guidance by the Home Office, and like I don't think it's simple as an immigration lawyer. I don't read it and think, yeah, do you know, if I wasn't a trained immigration lawyer, I'd understand what the hell I was doing.
No, absolutely. I think it's welcoming that the Home Office are now putting different sections into different appendices of the immigration rules, so they're easy to find and navigate. But still, when you've got sponsor guidance that's over 250 pages long, it's still very complicated, and there are lots of traps to avoid, certainly. What are things that applicants need to be aware of? What's the main requirements in terms of getting those points?
Sure. So the main requirements are that the applicant has a job offer, which must be at the minimum skill level, and it must pay the relevant salary for that job. They must be kind of criminality or good character requirements, so very similar to the general grounds of refusal. An applicant may not qualify for entry clearance if they have a criminal conviction, or if there's anything in their character or conduct which would indicate that their presence in the UK is not conducive to the public good. There's an English language requirement at level B1 of the CEFR, and then finally there's a financial requirement, so the migrant would need to demonstrate access to a certain amount of money unless the maintenance is being certified by the sponsor.
Absolutely. So we've got these mandatory points requirements that are there, and it's interesting, as part of the sponsorship requirement, the decision maker mustn't have reasonable grounds to believe the job has been created mainly so the applicant can apply for entry clearance or permission to stay. So there's still these huge subjective elements within the new rules.
Yeah, that's correct. So kind of one of the main points that the Home Office were talking about was their kind of abolishing the resident labour market test. So the resident labour market test is now kind of a usually mandatory advertising period for a job in the UK. The rules are very prescriptive in terms of where you can advertise, how long you can advertise, and what a job advertisement must contain, what information goes in there. Now they have abolished that under the skilled worker route, but kind of as you say, you know, you have to prove that this role is genuine, which in turn may require some form of advertising for that job. In terms of how you advertise, where you advertise, how long you advertise, it's going to depend on kind of the company's procedures that they have in place, whether kind of they generally advertise for this role in the past. Yeah, it's just kind of case specific, I think.
And what would you be advising applicants, prospective employers to be doing now to prepare themselves for this?
Sure. So anyone hoping to sponsor workers under the skilled worker route will need to hold a sponsor licence. And if employers don't already hold a sponsor licence, I would strongly advise them, you know, if they are thinking of sponsoring workers in the future, to apply now. We imagine that come the new year, following our kind of the end of the transition period in terms of our exit from the EU, so that there's probably going to be a large number of applications going in. So yeah, sponsors should definitely think about getting getting that sponsor license in place now. Another important thing is for anyone who is employing EU workers at the moment, to make sure that that EU worker has a document to confirm their residence in the UK, particularly if they're going to remain in the UK beyond the 31st of December.
And you talked about EU nationals, then just switching to our other topic, looking at the EU settlement scheme. Obviously, if you've got EU nationals and the dependents now in the UK, you're going to be wanting to apply under the settlement scheme. Obviously, they've got until June next year, but in terms of the settlement scheme, how are you finding things at the moment, Gemma? What sort of applications are you dealing with? What issues are coming up?
So we're dealing with quite a lot of EU applications, and quite a large number of my ongoing cases at the moment are actually applications under the regulations, so not necessarily the EU settlement scheme, but for those who want to apply as, I don't know, like dependent family members, so people who aren't potentially covered under the EU settlement scheme. We obviously have a deadline of the 31st of December to get their applications prepared. In terms of issues, I'm seeing the Home Office kind of incorporate requirements that don't necessarily exist. So, for example, in these dependent family members, they're saying, you've only shown dependency for a limited period of time, and it's not necessarily a requirement to be dependent on the EU national for a certain length of time. We're also seeing the Home Office ask for a lot of documents, so documents that have already been uploaded to the online application system, they're coming back requesting more documents that in some cases just are not relevant. It just doesn't matter to the decision. But in terms of that, fingers crossed, I haven't actually seen an EU settlement scheme application refused.
Wow.
Good, I think.
And in terms of speed, how quick are decisions coming back at present? Sort of, we're recording this at the end of November during the second lockdown. How are things doing in terms of speed of EU settlement scheme decisions at the moment?
Not very speedy, I don't think. I'm dealing with a client at the moment, and we submitted her application. It was an indefinite leave to remain application. We did have to use the paper form under the EUSS, but her application was submitted in April or May, and I still don't have a decision. I was contacted by the Home Office to ask for more documents, but still no decision. Other applications, like online applications, I'd probably say up to about 8 weeks, I think.
And in terms of them asking for documents, is that happening in a lot of applications, or the minority or majority of applications? Do you find them coming back to you asking for more documents?
The minority. I think the majority of the ones that I've dealt with have gone through fine, kind of without any requests. But kind of where the Home Office have come back to me and asked for something more, it's always generally kind of additional residence documents or something like that.
And in terms, well, you haven't seen a refusal yet, which is good news, but in terms of, obviously, there seems to be three options. There's the administrative review option, or perhaps before that, there's the make a new application option, and you may have people coming to you, perhaps done it themselves first, and now coming to you to make a new application. There's the administrative review, or if you made an application after a certain date, there's options of appeal. Any thoughts in terms of remedies with EU settlement scheme applications that may be refused?
Yeah, I think it all depends on the evidence and the information that was provided with the first application. If it was properly prepared and the applicant provided all the right documents and information, if the decision is unlawful, perhaps go down the administrative review route. But if we could strengthen it, if we could provide additional documents to prove compliance with the immigration rules, then maybe I'd advise that we do a fresh application. So it's all going to depend on what the applicant provided, I think, in the first instance. I think that if one of Latitude's applications was refused, then we'd probably go down the challenging route, because we'll know that we provided everything that we needed in the first instance.
No, absolutely. And often you've got the option of administrative review and possibly appeal under the settlement scheme. So you could, look at that.
Yeah.
Gemma, you mentioned, just going back to something you dropped in at the start, I wanted to pick it up with you, not to catch you by surprise, but in terms of, you mentioned religious workers you do a lot of. Any sort of news, what's happening? How are they affected? Are they affected by the changes?
There are a few changes, nothing kind of drastic, I don't think, going forward with those. Again, the resident labour market test has been removed from kind of the tier 2 or T2 going forward Minister of Religion route, but strangely under the temporary route. So I deal with Tier 5 religious workers as well, that they are still subject to the kind of the resident labour market test, which I thought was quite strange, especially Tier 5 can only come to the UK for a limited period of time. Yeah, so nothing kind of drastic, I don't think. The rules are quite more prescriptive in terms of what duties someone can undertake. Across the board, they're helpful in terms of switching in between different immigration categories in the UK. So it's quite helpful, you know, if you come to the UK under Tier 5 and you want to switch into Tier 2 or T2 and Tier 5, T5, I'm going to have to get used to that, aren't I? They can switch more easily kind of between categories and things like that. But in terms of changes, there's nothing kind of massively significant, I don't think, no.
I think from my perspective, that's one of the positive things with the skilled worker route is the sort of ability to switch now, and within the student changes as well, there seems to be an opening up on the ability to switch into these routes. Still some things that you can't, often if you're a visitor, you still can't switch into these routes, but there's definitely an opening up in terms of switching into these new points-based system routes, which has to be welcomed.
And it is, you know, it's having to leave the UK just to apply to come back is quite frustrating, isn't it? But whilst we're talking about switching, there was an interesting point that came up in the training that I was doing last week. And the new entrant rate essentially would reduce a migrant's salary, but it's capped at 4 years. So they can only receive sponsorship and that reduced salary for 4 years. And that 4-year period would also include time that individual has spent in the graduate route, which isn't actually in force yet, and it won't be released until summer. But I thought it was something to kind of keep an eye on, because Joe, if you want to sponsor someone who's just finished a degree, you will benefit from a reduced salary because they're a new entrant to the labour market, but you could only sponsor them with that reduced salary for 4 years. They couldn't get kind of a 5-year sponsorship in the first instance.
No, so there needs to be some long-term planning in terms of you see an opportunity, especially for perhaps an employer or a new graduate, but equally there may be sort of implications further down the route.
Yeah, absolutely. So it's just something to be careful of, and something that isn't kind of necessarily really clear when you read the immigration rules and wonder why this route isn't as straightforward as what the Home Office are making out.
Absolutely. In terms of if people want to get in touch with you, if they've got questions or cases they want to bring to you, what's the best way to get in touch with you, Gemma?
Sure, so I'm based at our Manchester office, so I can be contacted over the telephone on 0161 234 6800 or by email at gemma@latitudelaw.com.
Gemma, that's brilliant. Thank you so much for your time and coming back again for a round two and covering such a broad range of subjects. I think we've touched upon the new skilled worker route, we've touched upon the settlement scheme, and we've thrown in religious workers as a cherry on top. So Gemma, thank you so much for your time.
No problem. Thanks for having me, Adam.
Bye-bye.